Hello, I'm going to talk about contract law concept of promissory estoppel. How does it work, when you need to discuss it, and how to spot it, etc. I'm going to roll a short clip about myself, and I'll get back to promissory estoppel very soon. Hello, my name is Kasey Shah. My slogan is a lifelong learner and a passionate teacher. I'm a California bar admitted lawyer since 2016. I'm also U.S. Patent and Trademark Office admitted patent lawyer since 2017. My goal is to provide value to you for your time investment in watching this video. Feel free to reach out to me via email, casey@hellolawacademy.com. Thank you very much. Let's get into promissory estoppel. So I have these study notes that I have created for all the topics, and I'm going to be using that. The rule statement for promissory estoppel. So let's start with that. Promissory estoppel allows party to enforce a promise in absence of a formal contract. When contract does not exist, keep in mind this is a consolation prize, if you will, for the person trying to impose this remedy. And there are a few elements we'll go through. One party reasonably relies on the promise to their detriment, and enforcement is necessary to avoid injustice. So all the elements are part of that rule statement. So let's understand each element separately. So elements here, let's understand. Clear and definite promise has to be there by the promisor. The reliance has to be there. The person who was made this promise to, promisee, must have relied on the promise. And the reliance must be reasonable. We always look at the objective standard in contract law. It has to be reasonable. You can't have very unreasonable reliance, and you have to analyze from a third-party objective person standpoint. If it is reasonable, then that's fine. Detriment has to be there. We are trying to enforce the detriment of the promisee in this case. So they must have suffered some loss. If there was no loss, then it does not qualify for this remedy. And injustice. Court must see that, oh man, that's really unfair for a promisor to say that, to promise that, and not carry it through. So court has to find that sort of sympathy for the promisee, for the party who is asking for a promissory estoppel application. As a part of this study note, I have an example as well for the promissory estoppel, so it gives you idea, and you can read through it. Essentially, the way it would work in promissory estoppel is someone is promising something and not carrying through the promise. And that promise creates a reasonable reliance on the promisee. They rely on it and do something to their detriment, and court will find it. It's just to enforce this, not as a contract. So in this case, every Lawson is promising to Jordan Blake that they will donate $50,000 to support Jordan's new nonprofit organization. Now, Jordan relies on this promise. So Jordan says, okay, thank you. I appreciate that. Relies on the promise and leases an office. This is the detriment piece. And hires staff as well. So these to his detriment, Jordan's detriment, every letter withdraws the promise. Jordan can potentially invoke promissory estoppel. Why not full contract? Because there wasn't any consideration. So I will walk through how you would do the fact pattern analysis shortly as well. And then in this notes format, very unique, and the one that works for me, I'll roll that tape as well if you're interested in how these study notes work. I also have a case citation, 1 or 2 cases, top cases that probably went through all the way to Supreme Court, if there is a case that went there, and how it was decided. So you can read upon it. And then I have this Kasey short essay fact pattern. I strongly encourage you to just write very short essays. It will build your confidence. You're going to be a different writer if you follow this format. I just have one essay question here, and I have given a fact pattern, and you just answer these questions. All I want is a couple of lines per each one of these questions, and you should be golden. If you practice along with me for all the topics that I go through, you're going to love it, your progress on writing essays. And I have a short quiz about this, yes, no type of. These are not the full-fledged MCQ. I have a separate section for that. But these are just short questions like, can a claim of promissory estoppel succeed without a clear and definite promise? No, there must be a clear and a definite promise. That's part of the element. So let's look at the element here. Clear and a definite promise has to be there. And second question here, is it necessary to prove reliance? Yes, that's also part of the element. Does detriment to the promisee alone suffice to establish promissory? Alone is a keyword here. No, it cannot be alone. There has to be a reasonable reliance. If you just made a loss, but it wasn't reasonable for you to rely upon such outlandish promise. For example, I'll give you a country in donation if you do certain thing. That's outlandish. It's not a reasonable reliance. So that is not sufficient. Quiz number 4 here. Can promissory estoppel apply if the promisee benefits? Benefits. If something happened, like you bought a crypto out of promise and crypto went up, that became twice. Well, you benefited. So there is no detriment. There is no loss. There is no injustice, right? If I go back up to the elements, has to be detriment. If you benefited, that's not detriment. And there is no need to enforce it for injustice because there wasn't injustice at the end of it. So that's how I roll. Explanation of the examples here. So there's some additional notes. Promissory estoppel is not a contract. It's a legal remedy. So keep in mind, it's not a full-fledged contract. And I have some other examples. So here is how I encourage you to address promissory estoppel in your essay for the law exam. Whether it's a first-year law school, bar exam, or your law college exams, any of those law exams where the contract law is tested, they should be good. When you have to review a contract law fact pattern, you obviously start with the mutual assent. You look at offer. Was there an offer? All the analysis about it. Was there a consideration? All the analysis about consideration. Was there an acceptance to the offer? Analysis about it. And no defenses. We do not want any defenses to take away. If all of these are true, then a K is formed. If not, that's when promissory estoppel should be analyzed. Now we have to look at the elements of all 5 elements we talked about, whether they apply to this situation. Generally, it will be gratuitous. Most of the time, it will be missing consideration. There was no consideration on the part of the offeree. So if offeree does not have a consideration, something was offered by promisor, then contract is not formed. But you can analyze under promissory estoppel whether it is necessary to avoid injustice. That's a big piece you need to address. And you can, in your essay for the law exam, you can analyze it. You don't have to answer it yes or no. You can say both ways. The judge or court must analyze under this because it feels like they had all the elements of the promissory estoppel in this fact pattern, and there must be some injustice avoidance here. But remember, it's a consolation price. So if promisor said they'll give 50,000 and promisee only suffered 10K detriment, then they only get 10K because no contract was formed. This is a remedy for promissory estoppel. This is a remedy for full contract. You see, this is like a consolation price. So that's how you need to analyze. Going back again here, I will have this PDF available at hellolawacademy.com. The website should be right here. You can download it and you can review it. So that should do it for promissory estoppel in contract law. Hope you understood it. If not, give me your questions and I'll be happy to answer those. You can also reach out to me directly. I have my email address, Kasey@hellolawacademy.com. I'll put it up there. So Kasey@hellolawacademy.com. Send an email to that. So that's promissory estoppel for all of you. A little bit difficult concept for law exams. Analyze it when you see, oh my God, contract wasn't formed, but there's a lot of injustice here. Let me address it. And it's about the remedy. It's about making promisee whole because they reasonably relied on a promise by a promisor to their detriment. And we need to make them whole. The court needs to make them whole. Kasey Shah signing off. Thank you very much.